case briefs, and so much more. LSData's got what you're looking for.
The Court of Appeals of New Mexico recently heard Bartlett v. New Mexico Welding Supply, Inc., a case focusing on the liability in a pure comparative negligence system, where each party involved in an accident is responsible for their share of the damages based on their degree of fault. The case stemmed from a 3-car accident in which the lead car quickly pulled out of a service station, causing Jane Bartlett, the plaintiff, to slam on her brakes. Consequently, the defendant's truck crashed into Bartlett's car. The jury found the defendant 30% responsible and the unknown lead car driver 70% responsible. The court had to consider whether joint and several liability was still applicable in states that have adopted pure comparative negligence, and whether a concurrent tortfeasor is responsible for the entire damage caused by concurrent tortfeasors in a comparative negligence case. Ultimately, the court decided that joint and several liability did not apply in a pure comparative negligence system, and damages must be apportioned based on fault. Each party is liable only for their proportion of the damages. As a result, the order for a new trial was reversed, and the plaintiffs were awarded 30% of the damages caused by the defendant.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.